Good afternoon, everyone. A warm welcome to our workshop, Platform Governance and Duty of Care, which is co-organized by INSPA, a higher education institution in Brazil, and the University of Sussex in the United Kingdom. My name is Beatriz Kira. I am an assistant professor in law at the University of Sussex, and I'm going to be your on-site moderator today. And I'd also like to thank our online moderator, my colleague Phoebe Lee, professor at the University of Sussex, and our rapporteur, Ramon Costa, who is here today. The central challenge that we are going to gather here to address today is one that defines our digital era in 2025. How to build and maintain trust in the online spaces that have become so central in our lives. The threats that we face are neither abstract nor distant. They include, for example, disinformation campaigns that can swing elections, hate speech that spills from screens into the streets, and real-world harms, and coordinated harassment that could silence marginalized voices. For a long time, the debate on how to tackle these issues have often revolved around inadequate solutions. But with time, the conversation has matured, and we have now decisively moved away from relying solely on self-regulation by platforms into a more regulatory model. Around the world, the ground is shifting, and we see, for example, the European Union's Digital Services Act, which addresses systemic risks. We see in the United Kingdom, where I'm based, the Online Safety Act, which pioneers the idea of a duty of care approach. And we also see in countries in the Global South, like Brazil, where the Supreme Court is currently reinterpreting intermediary liability within the Marco Civil da Internet. And what we are seeing emerge here is not only kind of a new approach to regulation, but kind of different approaches altogether, different strategies. And duty of care, which is the topic of our workshop today, is one of them. It represents a departure from traditional intermediate liability models, and rather than solely focusing on what platforms should keep up or take down, it asks what can platforms do to create and to promote a safer environment online. With this shift, there are new opportunities for new spaces for most stakeholders, and, for example, oversight institutions, fact-check organizations, civil society, and users have the opportunity to play new roles, and these are the things that we want to discuss with you today. But I think the crucial question motivating us and this debate is precisely what does adopting a duty of care approach to platform governance actually mean? This question sits at the center of a research project that I coordinate with my colleague Ivar Hartman, which is funded by the British Academy, and it compares experiences in the UK and in Brazil. Last year, we hosted a multi-stakeholder workshop in Brazil to explore this question, and the insights that kind of were discussed led to a publication of a report early this year, where you can find the main findings that we published. It is freely available, and I really encourage you to read and to download. And building on that discussion and building on the findings from this report, one of the key issues that we learned is the importance of learning from different jurisdictions, so not only Brazil and the UK, but how are other jurisdictions and other actors also considering in terms of duty of care approaches to platform governance. And this led us to organize this workshop here today, and we're very thankful to IGF for hosting us. Today, we have 5 speakers that bring to the discussion something very valuable, which are real experiences from different continents, different countries, different regulatory environments, to tell us a little bit more about what it means for a duty of care approach to being embedded in platform governance and platform regulation. So we have representatives with kind of more public sector experience, internet governance bodies, journalism and academia. So just kind of rounding up this introduction and kind of the housekeeping for the session, we are going to start with kind of a round the table session with each of the speakers making their initial remarks for around 7 minutes. So they're going to introduce themselves and make their initial remarks in about 7 minutes. And then I'm going to open the floor for discussion, for debates. I really hope that you can engage with us, make this a really engaging conversation, and not only me talking to to you or them talking at you. So let's thank you again for being here. Let's begin. We have the first speaker today, Amelie. Amelie is online with us, joining from Germany, I believe. But Amelie, I'm going to give you the floor. You can introduce yourself and tell us a little bit more of the kind of European perspective to this issue. Thank you.
Thank you. Thank you for having me. Do you hear me well?
Yes.
Okay, good. Yes, I'm joining from Germany online today, unfortunately. My name is Emily Helt. I work at the German Federal Chancery, but I'm here today in my personal capacity and as an affiliated researcher with the Leibniz Institute for Media Research in Hamburg. And I'm happy to talk a little bit about the situation in Germany and in Europe, just briefly, and then we can go into details later on. So what the German situation is that we already have a general duty of care between contractual partners. That's something that is in the BGB, our civil code here in Germany, and it's something that has been used in the past to actually test terms and conditions of online platforms. To be, or specifically also to see to what extent platforms can be bound by freedom of expression. So in the framework of a horizontal effect of freedom of expression. So that's like the starting point that we had. Then, as you're probably or maybe aware, there was the e-commerce directive here in Europe. That's the predecessor law of the DSA. And Germany then adopted in 2017 a law called the Network Enforcement Act, the NetzDG, which also which obliged platforms to implement a system of notification for users so they could actually flag content as being illegal. Later on, or now that we have the DSA, this obviously replaced the NetzDG. And in the DSA, we have much more duties, quite specific duties for for platforms to act against illegal content. One thing that I would like to highlight today, what I think would be interesting for the discussion, is the role of trusted flaggers under the DSA. Trusted flaggers are in Article 22 DSA. It's as you're maybe aware of, an instrument that has been used by platforms in the past. So we could assume it's sort of a best practice of online platforms that has then been integrated into the Digital Services Act. And the Digital Services Act contains rules, meaning that the regime of trusted flaggers is the following. They can notify or they can flag content, but only illegal content. So they have to or it's under the provision of Article 16 DSA. And how do you become a trusted flagger? You will be will be a process of certification with the Digital Services Coordinator. That's the main public authority in charge of the Digital Services Act in the respective member state. The flaggers, they flag the content, and then there will be a speedy check by the platforms, which then decide whether they want to remove it or not, whether they think it's illegal or not. So it's kind of, you could say, a multi-stakeholder instrument. And as I mentioned, it was already in use before the DSA. And the discussion that has been going on around this is the question how to evaluate actually the role of private actors in this sector that are the organizations that can be that will be trusted flaggers under Article 22. In a way, or some people say they have been they act on behalf of the state, so they can be considered state actors, which would make which will change their legal status in a way that they would be bound by other rules and will be closer to state action, and that's relevant for anything that goes against freedom of expression or against user content. There's also the question how to deal with organizations that are mainly focused on a private interest, such as intellectual property, that's often in a context that's commercially used. So this is the big discussion. Obviously, it helps when it comes to hate speech because the removal will be more speedy, and that's something that has been advocated for a long time. So I'm happy to dive a bit deeper into this use case later on. But what I wanted to highlight here is, to sum it up, is sort of the hybrid governance that we have here between a law like the Digital Services Act that's not only about platforms being compliant and the state in charge of reviewing their compliance, but also private actors such as NGOs also that can be funded by the state taking an active role in the implementation of the DSA, and it makes the whole context more difficult, and it needs to be assessed carefully how to jungle with these new instruments, and it's quite complicated to untangle the legal relationships between all these actors. So that's quite specific. I'm happy to also talk about the DSA more generally, but I thought this could be interesting for our discussion.
But this is
Thank
wonderful.
you.
Yeah, thank you so much, Amelie. And it was a really good opening in terms of highlighting not only kind of what's the model or the kind of the groundings of duty of care domestically, but also kind of the supranational model of the GSA. And I think we are going to continue in some form of this kind of national and supranational perspective, but now bringing in the perspective from South and Southeast Asia. So we have Janjira, who's going to tell us a little bit more about that. So yes, the floor is yours.
You hear me, yeah?
Yes.
Okay. Thanks so much for having me. And so my name is Janjira. I'm a political scientist working at the university in Thailand, Chulalongkorn University, and the German Institute for Global and Area Studies based in Hamburg. And so over the past years, I've been doing research, collecting data on legal tools used to tackle disinformation problems in South and Southeast Asia. And at the same time, in Thailand, we also survey experts' views on the impact of disinformation on electoral integrity, social cohesion, and information integrity. And so before we jump right into the conversation about platforms' duty of care, I just want to begin by sharing some preliminary findings from our survey from the project in Thailand. So the surveys actually explores experts' views, as I said, and we launched the surveys in 4 Southeast Asian countries: Indonesia, Malaysia, Thailand, and the Philippines. And what is so interesting is that the majority of respondents, around over 65%, expressed distrust in government regulatory frameworks. And I'm not really surprised, to be honest. Low trust in government's genuine commitment to protecting citizens from online harms underpins public skepticism towards state-led regulation of platforms. And I think that's why we kind of want to move forward to multi-stakeholder approach. And so I find the results quite telling, underscoring how political context shapes platform governance and, the debate on platform governance. And I think when we discuss this issue, we have to look at various forms of threats that online users and citizens face. So it's not only disinformation in Southeast Asia, but we also have trends in autocratization. And so the issue in the region isn't whether governments can legislate, but whether they can enforce these laws in ways that uphold the rule of law and due process, right? And so public mistrust is further reinforced by the increasing misuse of such laws. And there are plenty of laws in the region to suppress freedom of expression, as seen in a host number of countries, including Thailand, where I'm from, Cambodia, and especially the Philippines under the Duterte administration. So online critics face harsh penalties, while platforms are pressured to remove politically sensitive content under the guise of combating disinformation. And so my point is, in practice, enforcement often becomes partisan, at least in Southeast Asia. And in the context where today's opposition might be tomorrow's government, these laws can be quite conveniently weaponized. My point is, while legal and regulatory tools are important, they are not a silver bullet. And I don't know if this point would be considered contradictory to a lot of folks at the IGF, but my research shows that public preference leans toward not only a multi-stakeholder approach, but also greater synchronization across initiatives to improve the integrity of online information. And I like to call this approach as a pluralist approach, which is slightly divergent from a multi-stakeholder approach, not completely new. So the approach includes not only regulatory frameworks grounded in platforms' duty of care, but it also moves beyond the legal sphere to encourage participatory fact-checking, structured pre-bunking efforts, and community moderation initiatives. So I'm just gonna spend the last 2.5 minutes giving you some sort of examples, illustrative examples of how this approach has been trialed in the region. I just mind you that each of the case that we study doesn't have the comprehensive package of this approach, right? So, and one example comes from each country, so it's just quite fragmented still. Now, regarding the participatory fact-checking, in Malaysia, for example, after the repeal of the Anti-Fake News Act in 2018, journalists and civil society actors began advocating for the creation of the Malaysian Media Council, or the MMC, which is an independent self-regulatory body tasked with handling public complaints, countering disinformation, and engaging with tech companies. And in Myanmar, Thailand, and the Philippines, for example, civil society organizations have collaborated with platforms and parliamentary committees to flag accounts. I think actually an approach very similar to what the previous speakers suggested. So these CSOs have collaborated with platforms and parliamentary committees to flag accounts suspected of coordinating disinformation campaigns. So the idea is not only to flag and target false content, and I highlight content, but also to address a deeper political economic root of online influence operations and to disrupt their financial incentives. Last but not least, the pluralist approach helps ensure the regulatory frameworks are anchored in initiatives driven by broad-based segments of society. And this idea of a coalitional, a pluralist approach to platform governance is so important because at the end of the day, it's about creating democratic legitimacy for such frameworks for society to adopt, accept, and pursue the goal of combating disinformation together. So I'll stop here.
Thank you so much, Indira. And it was really interesting to hear that kind of how the relationship of trust between users and the government and users and platforms is not uniform across different settings, different jurisdictions, and how that informs also the kind of the governance arrangements, as you mentioned. So if we contrast with what Amelie was telling us about kind of a more regulatory-driven efforts, we heard from Indira now a more kind of civil society-driven, but similar in a way, kind of trusted flagger, participatory fact-checking initiative. Thank you so much. Wonderful. So we are going to move on to kind of around the globe efforts and overview. We have now, to my right, Bia Barbosa from Brazil, who is going to introduce herself and talk a little bit about kind of the perspective from Brazil. And there's a lot going on, so it's a challenging position to be.
In 7 minutes.
Yes. Yeah, thank you, Bia.
Thank you so much, Beatriz, and Professor Rivar as well for the invitation for the Brazilian Internet Steering Committee to be here. I know that our member from the Brazilian Internet Steering Committee also helped to organize this activity, so thank you so much for everybody being here. I'm a journalist, and I'm speaking on behalf of a civil society where I belong to that's called Communication Rights and Democracy, which member of a huge coalition, Rights in the Network coalition in Brazil that gathers more than 50 civil society organizations that struggles for different rights online, and a civil society representative of the Brazilian Internet Steering Committee. So I'll try to begin by summarizing a little bit the current state of discussions on duty of care in Brazil, focusing mainly on two different perspectives on the table, and then present the contributions that we have at the Brazilian Internet Steering Committee, the CGI.br. The idea of duty of care began being discussed in Brazil based on the proposal by the government, inspired by the debates in UK, which included this concept in the bill on transparency, freedom and responsibility on the internet. At that time, in 2023, the government's proposal was to establish a duty of care for social media in relation to the circulation of illegal and harmful content that could promote hate speech, racism, violation of children's rights, and attacks to the democratic rule of law. It's important to remember that this happened shortly after an attempt of coup d'etat that our country suffered after the far right lost the elections at the end of 2022. As in the British Online Safety Act, social media would not be responsible for individual content, but rather for their responses to the general circulation of such content. At the same time, the bill spoke of the duty of companies to mitigate the systemic risks generated by their services. The presence of these two different concepts in different articles of the text, in my opinion, raised concerns that the proposed duty of care would result in practice in a change of the civil liability regime of platforms, presupposing a duty of immediately remove such content in an automated manner. This position has been enforced by different government actors, including in the context of the trial currently taking place in the Brazilian Supreme Court. There are two cases under joint discussion. Today we should hear the opinion of the last justice on that. There are 11 justices. And the cases analyze the liability regime for intermediary that has been in place since 2014 under the Brazilian Civil Rights Framework, Marco Civil da Internet in Brazil, which in his Article 19 states that application providers, all of them, and I will go a little bit further on that, can only be held liable for damage caused by third-party content if they disobey a court order to remove it. The Brazilian Supreme Court already has a majority of votes to change this regime, so 8 votes for now out of 11 justices have been cast in this direction, and the content of duty of care has been cited many times, mentioned many times by the justice. What is still unclear by the votes is whether the court will completely change the liability regime and consider social media as publishers, equivalent to the media outlets, for example, responsible for everything that is published, or whether it would only apply to content, illegal, harmful, we don't know, that must be proactively removed. As this is a case that deals precisely with civil liability, that is, liability for individual content and not just systemic risks, there is a reinforcement of this interpretation that the concept of duty of care is related to civil liability. And it is also unclear how the Supreme Court will ensure the implementation of its decision. Consider that under Brazil law, civil liability must be determined by the courts, and also consider that Brazil does not have a regulatory authority or body to deal with this topic. That is why a significant part of civil society, including organizations that are part of the Rights on the Network Coalition, which I belong, has raised important concerns about the idea of duty of care, especially in light of abuses already committed by platforms that have unduly silenced the voices and struggles of minority groups in Brazil. In a context where they may become legally responsible for this content, there is no doubt that abuses will multiply. And if we are to have, as we hope, a slightly healthier environment in terms of the removal of illegal content, we will also have an environment in which critical voices, journalists, and human rights activists and defenders will become even more victims of a private censorship. That is why this part of civil society strongly advocates that Brazil move forward with regulation through the parliament, which can prioritize the regulation of process, algorithms, and content moderation mechanisms rather than individual content, in a perspective closer to the concept of addressing the systemic risks of this service. We understand that Supreme Court ruling is important in a context where the Brazilian parliament has been unable to make progresses on this issue. The bill I mentioned before was blocked in 2023 by pressure from big tech companies in alliance with the far right. That was anything but Republican. And however, depending on how the court concludes this trial, we may have a situation where this decision is not implemented, or even worse, a worrying impact on all application providers. This is why the Brazilian Internet Steering Committee, which defends the constitutionality of the Article 19, precisely because its application it's applied to all providers, has prepared a technical note proposing a typology for application providers to assist the Supreme Court. This typology is based on the level of intervention of companies in distribution of third-party content and emphasize the need to modulate the accountability of agents according to their functionalities, proposing appropriate and proportional liability. According to CGI's technical note, the analysis of Article 19 should observe the following distinction. Application providers whose functionality does not interfere with the circulation of third-party content. Those that operate in the internet as a simple means of transport or storage, such as website hosting or email providers. A second typology would go for applications providers whose functionality has low interference with the circulation of third-party content, such as websites specializing in editing articles and entries. And application providers whose functionality has a high interference on the circulation of third-party content, potentially constituting a risky activity. So this interference includes profiling, mass dissemination, algorithm recommendation, micro-segmentation, strategies to continue engagement, paid content, targeted advertising, among others. So we believe that Supreme Court's decision should apply to these providers, which are far from being neutral intermediaries. Finally, reinforcing the potential for multi-stakeholder construction of balanced and democratic regulatory proposals, I'd like to share that looking at the task assigned to the Brazilian Parliament, the Brazilian Internet Steering Committee has also launched a public consultation on principles for the regulation of social media. 3 of these principles relate somehow to the idea of duty of care: the protection of freedom of expression, privacy, and human rights online, the protection of information integrity, and prevention and harm and accountability. In this sense, and I'm finishing, I promise, in this sense, CGI proposed for debate the idea that social media should make their best effort to prevent and guard against potential harm arising from their activities, especially those arising from the circulation of content, understanding that they are responsible for the harm arising from systemic risks inherent to the services provided, and should repair or mitigate them. Damage resulting from systemic risk is understood to be caused by network environment resulting from its policies of transparency, moderation, recommendation, and content boosting. So thank you very much once again, and I'll be happy to go further during the debate.
Thank you so much, Via. And I think it's interesting to see how the kind of, in theory, the same concept of duty of care has been mobilized differently, not only across jurisdictions, but even within the same jurisdictions by different kind of stakeholders. So the Supreme Court understanding and interpreting this from one perspective and more kind of linked to the idea of intermediate liability, whereas the efforts that we see or have seen in the past in terms of legislative efforts being more kind of the systemic approach, in a way more similar to the UK and the EU. And I think kind of in this tune and kind of how parliaments have been trying to kind of embed the idea of duty of care in legislation, we are now joined online by Yvonne Chua, who is going to bring us a perspective from the Philippines. So Yvonne, thank you so much for being with us here today. I imagine it's quite late for you. So yes, please go ahead and introduce yourself, and you have the floor for your remarks. Thank you.
Hello from Manila. Don't worry, it's still evening, early evening in the Philippines. I'm Yvonne, and I teach journalism at the University of the Philippines. You know, I'm really glad we're having this conversation because in the Philippines, we've been stuck for some time. For years, our lawmakers have been proposing to fight disinformation and online harm by focusing on punishing the users, primarily tightening libel laws, ramping up cyber libel, and proposing stiffer penalties. But we've seen where the existing laws have led us, citizens and journalists sued and even silenced. And the platforms that enable virality, amplification, virtually untouched. That's why a report by a House or Congressional Tri-Committee released a few weeks ago feels like a turning point. For the first time, it explicitly recognizes that platforms have a duty of care and that duty can and should be regulated. Now, just a bit of context, the Cybercrime Prevention Act in the Philippines, combined with our colonial-era libel law, have put hundreds of citizens, including journalists, through libel. Libel is a crime in the Philippines, and more than 3,800 cyber libel cases have been filed since 2012 when the law took effect. This figure underscores the significant reliance on criminal libel as a tool against speech online. And it doesn't stop there. We have the anti-terrorism law of 2020, for example, widening the state's surveillance powers and introducing dangerously vague speech restrictions. So while we jail users, no Philippine law holds platforms accountable. That brings us to the House or Congressional Tri-Committee on Public Order, Information and Communications Technology, and Public Information. After months of hearing with government agencies, academia, the private sector, fact-checkers, data scientists, and even influencers, the committee recently concluded, and let me quote, "Our putative toolkit is grossly inadequate and ill-equipped to counter well-funded disinformation ecosystems." The committee proposed something new, at least in the Philippines. Its 11 recommendations address three major themes: platform regulation and accountability, governance of oversight and ethics, and literacy and enforcement. In the interest of time, I'll focus on those that are highly relevant to today's conversation. First, the committee proposed a review and amendment of the Cybercrime Prevention Act of 2012 to explicitly define social media platforms, prescribe penalties for their participation in content-related offenses, and incorporate provisions on disclosure of data, parameters for auto-blocking of content, and preservation and retention of data. In the case of access to platform data, this is really intended to address the problem when platforms keep refusing to accommodate requests for data by citing American laws or US privacy laws in particular. Closely related to this is another committee recommendation to enact or pass a new law that would establish a comprehensive legal framework against false or harmful online content. It seeks to authorize government agencies to issue takedown, rectification, and block access orders. Now, that's the problem. While both recommendations emphasize intermediary obligations, the proposed provisions on content blocking or takedown could easily lead to overreach without clear limits. In the Philippines, a similar takedown clause in the cybercrime prevention law was already struck down by our Supreme Court several years ago for bypassing judicial review. We don't want to have Singapore's POFMA in the Philippines. As worrisome is the franchise proposal. The Tri-Committee recommended that foreign platforms maintain an in-country office that can be held legally liable. No problem with that. It makes sense to clarify jurisdiction and ease enforcement. But the committee also recommended that platforms secure a congressional or legislative franchise, just like traditional broadcasters or certain public utilities, in order to operate in the country. This is deeply problematic. We've seen this before when ABS-CBN, once our country's largest radio and television network, lost its congressional franchise in 2020 because the allies of then President Duterte refused to renew its franchise. It wasn't about media standards. It was political retaliation. So franchising platforms risk turning speech regulation into a partisan weapon, and any accountability bill that includes a franchise requirement must guarantee ironclad due process and protection from political pressure, or better yet, just shelve the whole idea. I just want to point out that can platforms actually meet these obligations? The answer is, of course, yes. They've already shown us that they have the capacity. They've responded to crises, elections, and coordinated harm in the Philippines and elsewhere. When regulatory expectations are clear, just as they are in the EU, the UK, and several other countries, platforms adjust. They set up task forces, they take down harmful content, illegal content, and they would even tweak their algorithms. So where do we go from here in the Philippines? At noon of June 30, a new set of lawmakers will assume office. So the Tri-Committee's work right now will be archived, but its findings certainly leave us a path. We can continue to criminalize users and chase trolls, or we can follow the path that it has pointed us to and finally hold platforms to account. Duty of care is not a silver bullet, but it shifts burden upstream where the harm begins. We've seen it work in other regions, in other countries. We've seen it can work here during elections and emergencies, but we need to build in safeguards. We need to make sure our laws protect free expression and human rights, even as we build a healthier, more trustworthy information space. Thank you.
Thank you so much, Yvonne. Yeah, no, I think it was heartening to hear from you in terms of kind of like how difficult the situation is, not only in Brazil, as you heard from Bia, but kind of other jurisdictions. And the Philippines is a great example, kind of trying to kind of balance the very important goals of kind of promoting safety and trust while upholding freedom of expression and not really giving the government of the turn powers to kind of overstep and kind of interfere with these rights. But also good to hear from you in terms of kind of course, there are ways of doing that, right? It's a mix of kind of political will, collaboration, cooperation, compliance from the platforms, but it's not an easy task to put together the legislation or the regulation. Thank you very much for that. And with this, we're moving to our final speaker for today, my colleague Eva Hartman, who is going to bring a little bit more kind of the summary of the challenges that we heard today as we prepared the floor for questions. So just kind of let you know that after Eva, I'm going to open the floor for questions, so you can start thinking about the questions you're going to ask our speakers, and you can kind of pick up the different points and ask them to kind of unpack something. Yes, so think of your questions while we hear Eva's presentation. Eva, the floor is yours.
Thank you, Beatriz. Thank you to our speakers who agreed to join us in this important yet complex discussion, and thank you for everyone who is joining us in the conversation as well here on site and online. Different workshops and panels here at the IGF have different strategies to making sure that it's actually a conversation, a debate, and not just different people speaking in sort of an isolation. So our approach was that I'll try to sum up, obviously not 100% of all the important comments and contributions, but make an effort to connect the realities in all these 4 jurisdictions that were discussed here, trying to take a shot at interpreting the valuable information and lessons that we heard from all these 4 jurisdictions. And I'll do that by looking at this from 2 different perspectives. One is what have been the challenges to creating and enforcing duty of care mechanisms and regulation in different jurisdictions, and what have been the concrete solutions that our speakers have shared with us, have been at least proposed, if not attempted, or have worked in these jurisdictions. One thing that I think unites, if not maybe the European Union and the jurisdiction that Amélie so kindly talked to us about, but certainly unites Thailand, Philippines, and Brazil, is that there is a perception by civil society and many stakeholders that there's a delay by Congress to offer, to provide, to actually create a framework that will address these more pressing issues that maybe everyone knows about, how problematic disinformation is for at least 10 years, but the more current versions of this and how it operates, money trail, that sort of thing, that regulators in these countries have not been quick enough to adapt. And that certainly has been the case in Brazil, as Beatriz has told us. Basically, the main challenge is that because of the delay by Congress, as soon as the Brazilian Supreme Court steps up and strikes down the current rule for intermediary liability for platforms and offers in its place an unclear description of a duty of care supposed framework, that this will create a fear on platforms and therefore on its users that instead of the old regime, which was not strict liability, was based on a trigger of there should be a court rule in order for a platform to be responsible for illegal content. In the first case, that court comes in, strikes down that rule, and then what's left, because of a void of Congress legislation, that what's left is an unclear framework, and that probably might lead in many cases to strict liability. The solution that is presented to this version of duty of care, which is obviously unwanted, I think, for everyone here, would be, as Beatriz has told us, a new bill that civil society is backing almost entirely, in its entirety, that would clearly separate types of providers and intermediaries based on their roles. So it should make clear, which is something that it seems the Supreme Court creating its framework will not do, separate cloud storage hosts from social media platforms to advertisers, a typology that would make predictable and safe for each company to understand what the law requires and then decide their course of action. Again, in the Philippines and in Thailand, it seems that civil society does not find the current frameworks as useful as they needed to be to ensure safe and protective online content moderation. It seems as Janjira brought to our attention, a survey of 4 different Southeast Asian countries has shown that a majority of people distrusts government regulatory frameworks. So merely creating a new law such as the DSA in the European Union is clearly not enough. So she tells us of a pluralist approach, one that would ensure representation from all segments in society, creating roles, multi-stakeholder roles, embedded in this regulatory framework, because at the end of the day, it is about creating democratic legitimacy for content moderation, if I understood Janjira correctly. So she tells us about citizen fact-checking, independent self-regulatory body tasked with engaging platforms and handling complaints. So there is an intermediary to the intermediaries and the government and the users. And to my understanding, it seems we have similar concerns also in the Philippines, as Yvonne has told us. She tells us it seems legislators have been stuck for many years. Overall, platforms are virtually untouched in either their failure to remove problematic content or when they do, when they over-censor. And she brings to us news of this important report by a congressional authority that is basically identifying one of the biggest problems with a version of duty of care framework or government framework, which is the excessive or, let's say, undue use of government oversight in such a framework to actually, whereby government, as in the past in the Philippines, she tells us has happened, would actually retaliate against digital platforms by forcing them to remove content that's actually not illegal. So the solution then, the concrete solution would be to guarantee in the law due process, to also guarantee access to platform data, to do a full review of cybercrime law, to avoid interpretations of libel laws that would mean legal content gets removed, even though it's legal just under the guise of alleged defamation. And lastly, that would prevent against content blocking that is an overreach by platforms. So in summary, I think there are, of course, not identical challenges, but challenges in these 4 jurisdictions that are very similar in their roots, because as we know, the problematic business model is a worldwide business model of algorithmic recommendation and advertising. And the solutions are not exactly the same. And so the DSA to the challenge, as Emily has brought to us, to the challenge of the question of if you have a duty of care framework and you hope that civil society does fact-checking as well and identifies hate speech as well, well, then how do you figure out who becomes a flagger or a trusted flagger? How do you evaluate the role of private actors who take on this important task? Are they a state authority now, or can they, for the purposes of the law, be considered a state representative? Because that would mean state action that restricts freedom of speech, and so this has immense consequences. And so the solution there has been in the DSA, and obviously we don't have many, many years of enforcement yet, but we have some time of enforcement. And just to finalize, and I think this is an important place to end, because this is where it's perhaps most advanced in terms of how far the implementation is going, government certification for these flaggers, such that there are rules on the DSA, obviously, as Emily has told us, that decide, that establish what needs to happen, what are the rules for someone or a private entity to become a trusted flagger, so that we can avoid abuse whenever very specific commercial private interests are involved. Once again, lastly, just thank you to our 4 speakers, and I apologize for any misinterpretation that I might have made here.
Thank you so much, Ivan. There's lots I want to comment and continue the discussion, but I know that we have a key members of the audience that wants to ask questions. So I'm going to open the floor for questions on site and online as well. So please, if you're online, you want to ask a question, use the chat function, and then we're going to be monitoring that. And for people in the room, there is a mic to my left-hand side. So we already have 1 question, 2 questions from the floor. Let's take them in rounds, perhaps. Is that okay? Okay. Can you please start with your name and your organization, and let's try to kind of make the most of this with kind of more quick questions with a question mark at the end. Thank you.
Thanks. I'm David Sullivan from the Digital Trust and Safety Partnership. We work with companies on best practices and standards for trust and safety. My question for all the speakers is, how are the different legal frameworks that have been presented defining systemic risks? And how do you approach trying to identify risks that are not illegal content, but somehow would not wind up restricting access to information and freedom of expression? Thanks.
Excellent question. Thank you. Yes, we have another one from the floor. Yes, please.
I'm Baron Soka, Tech Freedom. I run a think tank based in the U.S., but I'm really here to thank you for focusing on the potential for abuse. I'm glad we're talking about that. I would suggest that when it comes to franchising, there are no due process safeguards that could ever make franchising or licensing safe. We've seen how governments around the world use franchising and licensing to extort whatever they can get from the licensees. My question is, when should we have confidence in due process protections, and what kinds of due process protections do we think will actually work in the face of increasingly lawless governments? The Trump administration clearly doesn't care. They'll run roughshod over whatever due process requirements are in place. I'll give you two concrete examples to maybe frame your question, my question. One, Article 73(2) in the Digital Services Act, I think doesn't get enough attention. It says that before the Commission can issue a finding of liability, it has to explicitly say what the platform should have done or should now do. So I'd like to hear your thoughts about that as a due process safeguard. And then just to close, in the United States, we've had this debate over the Kids Online Safety Act. Republicans have been very clear that they think the bill will be weaponized against transgender content. The bill's Democratic sponsors think that the safeguards they've put in place are adequate. I don't think so. I want to know what kinds of safeguards concretely you think would be adequate to ensure that duties of care can't be used against particular kinds of content.
Thank you so much.
Hi, Brianna. I have a very similar question. Recently, we have done a huge study on the implementation of or alignment with the DSA in the EU candidate countries. And it actually turned out, and something that's actually my question, maybe shifting the focus here a bit, but also I understand completely the relevance of due care of platforms, but I also want to kind of shift the focus back to the duty of care of the states. And the previous colleague actually asked more about the safeguards. I'm really curious because the DSA itself does not have these safeguards for the rule of law and due diligence. So I want to understand better whether your research in your respective countries and the legislative examples actually can provide us some more understanding of the due care of the states when implementing these laws to prevent any forms of abuse that will actually be detriment not only to the citizens but a broadly democratic setting, right? Leaving aside for now the platforms and how it will affect their business models.
Thank you so much.
Hi, I'm Yu Jie. I worked at one of the social media platforms at Legal Counsel before. So while we see there's a lot of progress in regulating illegal issues like illegal content, misinformation and disinformation, I have the feeling that some issues with platform governance that touch or caused by the core business model of these platforms, like attention-grabbing platform, such as, for example, endless scrolling, for example. There's some feature that really exploiting our dopamine system and cause excessive use and addiction. And I didn't see their current regulation touch much on these kind of core issues. So I'm curious if there's any thought from panelists, what's the direction of resolving these issues that address these challenges. Thank you.
I'm going to close the floor after the tall gentleman over there. So yes, last two questions.
Hi, Andrew Camping. I'm a trustee with the Internet Watch Foundation, but I'm not speaking for them. Firstly, I think it's really encouraging to hear this discussion and that there's at least an appetite for some action in this space when you consider the immense harm that approaches like Section 230 in the States are doing around the world. So this at least shows hope with appropriate guardrails, as the speakers have touched on. My question, though, is an aspect of it that you perhaps haven't mentioned, which is I believe that a general duty of care on platforms provides a lot of promise to cover new technological developments which otherwise have to be explicitly mentioned in legislation. And various sessions already this week have talked about how does legislation keep up with the pace of new developments. I think a general duty of care, in my view, is a way of doing that, putting the onus on the platforms to show appropriate risk assessments before they deploy new technologies. And I'd be interested in the views of the panel on that. Thank you.
Thank you. Final question, please.
Yeah, thanks a lot for a great panel. I was wondering, this is maybe more of a question to the other panelists except for Emily, but I'd be very interested in hearing her thoughts on this as well. DSA enforcement has become very geopolitically contentious under the Trump administration. And I was wondering that in developing regulation in other parts of the world, this is something that is playing a part as well. Whether you guys feel pressure to align your social media regulation a little bit with the US administration's take on that. So thanks a lot.
Thank you so much. You have a wide range of questions. Please don't feel compelled to all of you to answer all of them. You're very welcome to pick and choose. I'm going to give each panelist, each speaker, 2 minutes, and please stick to 2 minutes so we can hear from everyone. I know it's challenging, but again, pick your favorite one or your couple of favorites, and let's start in the same order that we had the panel. So maybe, Emily, you can start with your 2 minutes and make this kind of also the closing remarks. We can hear you.
Yes,
No,
can you hear me?
yes.
Okay,
Yes.
now, yes, okay, good. Yes, so there are many questions regarding the systemic risk definition. It's a tricky one. There is a legal definition in Article 34 DSA. However, I mean, this is only one side or one, of course, the definition of the legislator. There are whole PhDs being written on that matter now that I can't sort of sum up here. I think it's something we have to look at quite intensively. Also, in the context of the second question regarding safeguards, because anything that is not clearly defined can then also be misused, and there's a very thin line here that can be crossed. I'd like to address the question of the business model, which I think is a very relevant one. We have, the Digital Services Act actually contains a lot of rules regarding content moderation mainly, and then there's the Digital Markets Act that addresses the market power of big tech, basically. But there is actually no rule that really goes at the core of the business model of social media platforms. That's why there's a discussion at the European Parliament right now on a Digital Fairness Act, or an act that would actually look closer at addictive design of online platforms or of apps, but that's very much under discussion, and it's difficult, and that bridges or goes to the last question in the actual context where Europe is. There's a lot of legislation coming out of Europe and of the EU, and we are thriving to not only be the regulators but also to develop tech ourselves, and so a lot of people are asking for less regulation. So I'm not sure we'll see much more regulation in that space over the next month. We have to start implementing what we have right now first.
Thank you so much, Amelie, and thank you for sticking to a couple of minutes. Janjira, the floor is yours.
All right. So so many great questions. I just speak broadly because of the 2 minute limit. Now, I think the two issues here I want to address. One is risks, right? In Southeast Asia and specifically the ASEAN, I mean, the sort of collective efforts to curb disinformation is very limited, unlike the EU. So far, there are limited frameworks to govern platforms together. Individually, in each country, there are different definitions of what pose risk in online space, in platforms. And that can get tricky because these notions can be very vague. In non-political issues like public health, child pornography, gambling, violent graphics, these can be clearly identified and agreed on across different countries. But when it comes to political issues, each country comes up with its own identification or definition of what constitutes risk. And this again varies across political context in Thailand, and I think we would go to the Philippines as well. Cambodia, Vietnam, the notion of anti-state, the notion of defamation of political elites are part of risk in online system, and therefore it leads to abuse by state actors to impose laws supposed to curb disinformation. So I think the definition when it comes to a collective identification of what constitutes risk still fragmented in the region, and I think it leaves room for politicization. Now, oh, that's it. Okay.
That's
good.
it.
Okay.
I mean, hold a thought because we can kind of follow up during lunch maybe if you want to join us.
Cool.
Yes. Bia, please.
Yeah, I'm not going further on the lack of the problem of the lack of definition, because I think it's everywhere, and not only regarding duty of care, but regarding risk assessment, systemic risks and everything. So this is one of a pretty important step of regulation that has to be debated and has to consider each situation and the context of each country. Regarding the due process, the provision that we had regarding due process in the Brazilian bill on transparency and responsibility of internet had to do with the right to information about moderation of each one content, the right to appeal to that moderation. I think it's at least something that we have to guarantee in any regulation that deals with social media platforms. And there are risks, but clearly I think that the situation now is not working. We have pretty much evidence on the negative impact. It's enormous. So of course each country needs to consider its own reality, including the strength or the weakness of its democratic institutions to propose determined specific things. But one way that I think that could help regulators to not abuse their power is to make this a multi-stakeholder process. Brazil has models of deliberative councils that establish rules for the implementations of law or public policies. That's why we, as a civil society perspective in Brazil, not the Brazilian Internet Steering Committee in general, because we have not arrived at that point. We understand that any Brazilian authority that takes on this task must necessarily have a multi-stakeholder body to ensure the protection of freedom of expression and the quality of the implementation of the law independently of the governments in power.
Wonderful. Thank you so much. I think to close us, Yvonne, you have the floor to answer questions and final remarks in a couple of minutes. Thank you.
Yeah, this is so difficult. But
I know, I'm sorry.
Right now, we don't really have a definition. We really don't have a definition of systemic risk. And I wouldn't be surprised if our lawmakers would be looking to the EU's Digital Services Act for inspiration. But, they really have to, because our lawmakers are really so bad at defining things, including fake news, which is broadly and crudely defined. And it was a revelation during the congressional hearings that, academics, fact checkers, and everyone had to take time out just to explain to them the difference between misinformation, disinformation, and malinformation. It took like hours just to get the terminology right. As far as due process is concerned, things get so messed up in the Philippines, especially with the implementation of laws. And that's why we're very grateful that we have a strong, independent judiciary that we can rely on whenever things get rough. about the general duty of care for platforms, the provision. This is really something that the TRI committee is trying to work towards, because the recommendations cover not only existing problems but also AI and emerging technologies. So perhaps a well-crafted legal framework would be able to address that. Thank you.
Thank you so much, and thank you. Just wanted to see if Eva wants some comments in 1 minute. I have less than others. But yes, just take the moment to thank everyone for participating. I do want to take on the questions about general duty of care, specific duties from the gentleman from IWF, but we can do it offline. For the time being, we can please join me in thanking our panelists, our speakers, and members of the audience for your engagement. We do hope to continue this conversation around duty of care and platform governance. I mean, speaking on my behalf and perhaps Iva's, as we continue to work in our research projects. But I think, and I'm please correct me if I'm wrong, all the panelists are also going to be looking at issues around platform governance and regulation and duty of care. So reach out to us if you want to continue this conversation in your other spaces. And thank you, IGF, for having us. Have a really good afternoon and see you next time. Phoebe, Emily, and can you stay for 1 minute so we can take a photo? Yeah, stay online. We can have a photo of the panel. Thank you.